Welcome back to the 2023 verdict, and as you've seen that, we've got Mr. Kemasode Nwodu, who is a senior advocate of Nigeria and former Attorney General and Commissioner for Justice for Bayelsa State. Good morning, thank you for coming on today.
Good morning, viewers.
We know how hugely important it is to be on the right side of the law. We also have seen that the courts are playing and will play a very important role in these elections, either for the February 25th one or March or any other one at that, because several cases are before them which will impact one way or the other on these elections. You have been taking a look at some provisions of the law, both with respect to the Electoral Act and the Constitution, and you say that there are some clauses that are worthy of note that we should pay attention to, because we may have looked at it, perhaps, you know, we're taking it with a pinch of salt or not paid as much focus as we ought to. And the first of them, one of which is the on the Electoral Act, accreditation of voters and voting. Now, Section 47, we identify Section 1, 2, and 3 of that Section 47 of the Electoral, which you also pointed out. So we'll read through it, and then you take us through what your concerns are, as we will do some other selected portions of the Electoral Act 2022 and the 1999 Constitution. But if we look at the one that is on screen right now, Section 47 of the Electoral Act 2022, which says, a person intending to vote in an election shall present himself with his voter's card to a presiding officer for accreditation at the polling unit in the constituency in which his name is registered. 2. To vote, the presiding officer shall use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Constitution. Now, take a look at Section 3, guys. Pay attention to Section 3. Where a smart card reader or any other technological device deployed for accreditation of voters fails to function in any unit, and a fresh card reader or technological device is not deployed, the election in that unit shall be cancelled, and another election shall be scheduled within 24 hours if the Commission is satisfied that the results of the election in that polling unit will substantially affect the final result of the whole election and declaration of a winner in the constituency concerned. Well, Mr. Nwodu, everybody would have thought this is pretty straightforward, but you don't think so, do you?
The provision itself is straightforward, but in the implementation, there appears to be some issues, because by those provisions, particularly sub 1 and 2, accreditation must be by means of a technological device or a smart card reader. And INEC, of course, has complied with that by introducing the BVAS. But the issue is that beyond this procedure prescribed under the Electoral Act, INEC, in paragraph 19E, 2 and 3 of its guidelines and regulations for the conduct of the elections, has reintroduced manual accreditation, because it says upon the presentation of the PVC of the voter, the electoral official there would go through the manual voters register and then confirm that the serial numbers, although the relevant numbers are in order, and then tick it before the person can proceed to go and cast his vote.
No, before the person can proceed to accreditation.
To cast his vote. That's the accreditation. The first procedure is the voter would present his voter's card to the person with the BVAS. The person with the BVAS will go through the accreditation process. Once he satisfies himself that the person is duly registered, because the voters register has been fed into the beavers. It has access to it. So once that process is over, the person will be shifted to another APO 1 or 2 who has the voters register, the manual voters register. And the person will go through that manual voters register to confirm the name of the person, they confirm whether the number on the PVC is the same with the number on the register, and pictures and all the relevant details before the person will be allowed to go and cast his vote. And that is contrary to the provisions of the Electoral Act, because the National Assembly has, in its wisdom, done away with manual accreditation. So accreditation must be by means of a technological device. And it was done in that manner to eliminate the delay occasioned in the voting process by the use of manual register. It takes time. And that's why in many places you could, we used to see instances where they'll be voting till almost nightfall.
That's your argument. Some people
it's in the law itself.
No, just a moment, sir. That's your argument. Your argument is that that provision was put there to do away with delay. But some people will say that no, the provision of the BVAS or a smart card reader was to ensure that only the people who truly registered in that polling unit are the people who came there. Because in the past, we used to hear that almost all the names will be ticked in a polling unit, and maybe palm kernel, nuts, etc., will be used to, you know, thumbprint in some instances, or make the thumbprint of a human being. So if INEC is following the Electoral Act by using the BVAS to accredit, or smart, well, we've been told it's the BVAS this time around, to accredit, that is part of their procedure. That's right. That's in their guidelines. Don't you just think that if they're taking off the name off the voter register, that's like a, how will I put it now, more of an administrative procedure, so that perhaps that same person doesn't come back again and say, oh, I have been accredited before now. The BVAS, we're not certain, has a way of ticking to be sure that somebody who voted before doesn't come back and vote again. So isn't that a way of making sure that whoever it is that has been ticked off that register doesn't come back again, present himself again and say, oh, or herself, as the case might be, and say, oh, I'm Julie, I'm a voter, I want to be accredited once again, and vote? Isn't that more of an administrative procedure?
Not necessarily, because that was the procedure we had before, and the National Assembly clearly departed from it. Because imagine a situation where voting goes on till it's in the night, the security challenges. But with the BVAS, it does away with all those problems. It doesn't take time to vote, and with the BVAS, voting would take place within the specified time. INEC is bound to follow the provisions of the Electoral Act, and in any case, that administrative process or procedure, as you mentioned, cannot even be used anywhere else, cannot even be used in court. And the BVAS, which is a technological device, should have a way of knowing whether a person has come to vote a second time, because it has done the accreditation. Everything is there.
When you say it cannot be used in court, do you see any possibility of this kind of matter coming up in court?
Why not? It will. It will come up.
On what possible ground?
Somebody may even argue, because INEC has stated that the hard copy of voters register should be used. Somebody can argue in court that the voters register should still be produced in court. Before the introduction of the BVAS, if you are challenging election on basis of accreditation, over voting, so many grounds, you must tender the hard copy of the voters register. But in the present system, it's not relevant. You can't even use it in court because it's contrary to the provisions of the Act. There's no provision in the Act that enables or authorizes INEC to use manual accreditation, that's by use of the
some people will say that your use of words might be a bit misleading when you talk about manual accreditation, because there is no manual accreditation.
That's what it means.
No, there isn't any manual accreditation. And I'm just a little curious, because we've seen, this is not the first time that a BVAS is being introduced. Yes, this is the first time it's going to be used in a general election, but we've seen its use in 3 different off-cycle elections.
Yes.
In the elections in Anambra, in the elections in Ikiti, and the elections in Osun. And there has been no question from any of the political parties about this issue which you're raising about manual accreditation. There's been no issue. So from where is this coming from, sir?
We're lawyers, and a lawyer can look at a particular law and see what others are not seeing. Some may see it and may not raise it, but this is critical, because apart from any other thing, it costs a lot of money to print that manual, the hard copy of the voters register. You have almost 200,000 polling units, maybe 180, 190,000 polling units in the country. Assume that they spend 2,000–3,000 to print voters register for each unit. You are talking of like 500, 400 million naira.
It was printed in the first instance, and when INEC did the voter registration, there was a process that mandated it for it to paste, and I think it's still one of the demands of the Electoral Act, to paste this voter register at the polling units for people to go and raise claims and objections, verify that their names are there. There was no objection to that.
One point that I need to make clear is that the Electoral Act recognizes 2 forms of voters register: the electronic copy and the hard copy. And there are instances where hard copy will be used. People who apply for copies, you give them, and the Act says INEC should keep both electronic and the hard copy. But for purpose of the election, Section 47, 1, 2, and 3 are clear. Those subsections, they are clear as to accreditation. And the procedure allowed by law in those sections is electronic. So that is by technological device.
So from from the issues you've raised,
yes,
what is the cure?
The cure is that it should be abandoned. The paragraphs 19E, 2, and 3 of the INEC regulations are unlawful. They are illegal. They are contrary to the provisions of Section 47 of the Electoral Act.
How is this going to affect the elections?
Nothing.
If they abandon it or not?
No. If they don't abandon it and they go on with elections and there are delays in the conduct of elections, the election proceeds until it's dark. We know the problems associated with that in collation, moving materials. But if they stick to what the law has prescribed, has provided, election will finish at 2:30. They've conclude the vote, the counting, and they go for the collation. Let's look at another section here, Section 73, which has got to do with forms for use at accreditation. 173(1) says, the forms to be used for the conduct of elections under this Act shall be determined by the Commission. 2, an election conducted at the polling unit without the prior recording in the forms prescribed by the Commission of the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials made available by the Commission for the conduct of the election shall be invalid. What can the consequence of this be? It's a new provision in our electoral jurisprudence and is very important because an election in a polling unit can be challenged on this basis, because it says if the relevant details, particulars of the sensitive electoral materials are not recorded in the prescribed form prior to the election in that polling unit is invalid, which means INEC must ensure that it complies with that provision. And I've gone through the INEC guidelines and regulations a couple of times, and I do not think that sufficient attention has been paid to this provision of Section 73(2), that is in terms of the implementation. Because of its importance, I think that that form ought also first to be signed by the polling agents, like they sign the result sheets, and uploaded. Because in my opinion, even at collation, there cannot be, collation cannot commence without the collation officer seeing that form. Because the law says that the election in the polling unit is invalid if the details are not recorded in the form. So the first duty of a collation officer is to call for that form. Were electoral materials distributed? Yes. Where is the evidence? Did you record it in the form before the conduct of the election? Yes. I want to see the form. That is the beginning. He sees the form. Okay, so where are the results? You bring the results. And I'm taking it even a step further, which is that, let's take a scenario in a collation, maybe ward collation center, and a polling agent of a party says in one particular unit or in several units, that form was not used. And the collation officer refuses to produce it, or for one reason or the other, the form is not there. The party that polling agent is representing can, in an election tribunal, raise that point. If INEC later in the course of proceedings, the election tribunal produces that form, I'm
sorry, I'm yet to really understand what the issue is. Can I just read it again? I think is Section 73 sub 2.
Yes.
It says an election conducted at a polling unit without the prior recording in the forms prescribed by the Commission of the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials made available by the Commission for the conduct of the election shall be invalid.
Yes.
It's talking about, okay, without prior recording in the forms prescribed by the Commission.
Yes.
What exactly is the problem with this one? Is there a problem here?
There's no problem with it. I'm explaining the purport and importance of that procedure in the electoral process.
But assuming they don't even comply with this, would it be sufficient to invalidate any election if they say, well, there was substantial compliance?
The Electoral Act is very clear. The provision you read says the election will be invalid.
Wow.
It says it will be invalid.
All right.
So, and that's why I was explaining before.
Maybe for the election in that polling unit?
Yes, polling unit.
Of course.
Polling unit. It's polling unit. It's not the overall election. The election in the polling unit.
And if it happens in more than one polling unit, the same...
if it happens in all the polling units, the election is not ongoing.
Okay, let's go to Lagos.
Thank you, Chamberlain. Mr. Ward, I'm trying to understand, the consequence that you're bringing out also from Section 47 of the Electoral Act, but if you could articulate that, after you also answered this, from this one, Section 73, if we could tie it to other concerns expressed about the presence still of the human element in the conduct of the electoral process in its entirety. Some are wondering why, if the BVAS can authenticate the personal information details of the voter, that's the thumbprint and the facial features of the voter, why shouldn't the BVAS do same, for the voting process, instead of, the voting process to continue manually? Because the concern is that the human element is subject to manipulation. So if you could speak to that and, talk about the consequences that could possibly arise as a result of this, and then probably share with us what really are your concerns about, the Section 47, paragraph 19, which you raise of the guidelines. Are you saying that there is a possible manipulation of that process as well, which my colleague explained to be just a checkout of the accreditation, which has already been done, using technology?
All right, thank you very much. First, I deal with the issue of electronic voting. INEC cannot proceed at this point with the electronic voting because the necessary legislations have not been put in place. But an aspect of it, which has to do with accreditation, has been dealt with by the use of the beavers, or, as the Act says, other technological device. So that aspect has been dealt with. Then, back to Section 47, 1, 2, and 3. That is the accreditation process. The point I'm making is that INEC is an agency of the federal government and is bound by law to obey provisions of the Electoral Act. So if the Electoral Act has said this is what must be done, that is, accreditation must be by the use of a smart card reader or a technological device which INEC has brought, that is beavers, so be it. They are bound by it. They cannot, based on their own discretion, add something which the law has abolished. The law has abolished manual accreditation, and which is the use of the hard copy of the voters register. You look at it, you take the time it takes, it wastes a lot of time and it's expensive. That has been done away with. Have I answered? Is there any one I omitted to answer?
Well, if there is anything else, I'm pretty sure we're going to come to it. But let me quickly take you up on something a little different. And it's Section 65 of the Electoral Act of 2022. I'm just afraid that there might be some confusion about that. Look at it says the decision of the returning officer shall be the final. The decision of the returning officer shall be final on any question arising from or relating to unmarked ballot paper, rejected ballot paper, and declaration of scores of candidates and the return of a candidate, provided that the Commission shall have the power within 7 days to review the declaration and return where the Commission determines that the said declaration and return was not made voluntarily or was made contrary to the provisions of the law, regulations, and guidelines and manual for the election. Don't you see a possibility of some form of confusion that could arise? Because on the one hand, a declaration has been made, and then it could come back 7 days after to say, sorry, we made an error. And then, the whole thing, it makes a completely different declaration based on that review.
Yes, there's no foolproof system, but that section was introduced because of allegations before now that some returning officers were forced, put under duress at gunpoint to make declarations of results. So that's why that provision was inserted. Cannot be foolproof, but it's designed to address issues like that.
I don't understand. So what happens if there is contestation of that same review of INEC?
Yes, you go to tribunal. That is, INEC, the provision has given INEC the authority to re-examine the entire situation. Maybe people will make presentation, they will say the returning officer was compelled at gunpoint, INEC will call for evidence and maybe documentary, any evidence that will be available to it, and then it will make a determination which will either confirm the declaration made by the returning officer, or it could make any other declaration. And once that declaration of result is made, that becomes the result of the election, which could be challenged in an election tribunal by any candidate that is not satisfied with the decision of INEC on the matter. Is clear?
Well, I believe it's clear for Ayo. Mr. Wodu, let's go to section 134. It will be interesting to know your thoughts there. Of course, concerns have been expressed by Senior Advocate of Nigeria, Mr. Agbakoba, in the past, asking for INEC's interpretation. I want you to give us some bit of clarity, and I'm just going to read it for you. Section 134, subsection 2A says, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election, each of at least 2/3 in all the states in the federation and the federal capital territory. Is this the same as having scored 2/3 majority in 25% rather in 24 states? Is it the same?
Okay, first I must say that the provisions of section 134, particularly 2, 3, 4, are not very clear. First, in the first instance, as a first election, in my understanding of that provision, that is 1342 of the Constitution, is that a person can only be declared the winner of an election, that's a presidential election, if 1, he has the highest number of votes, and then 2, he has at least 1/4 of the votes in 2/3 of the states of the federation, and then 3, he has 1/4 of the votes in the FCT. All these 3 conditions must be met. Without meeting any of these 3 conditions, a person cannot be declared to be the winner of a presidential election. And that will lead to the conduct of what the Constitution calls a second election. That is under section 134, 3, and 4. And the major problem there, particularly with the second election, is the choice of the candidates that can participate in that election is not clear at all. The Constitution says 2 candidates shall participate in that second election. With the first, there's no problem, because the first is the person with the highest number of votes, the majority of votes cast in the election. There's no problem with that, but there's a big problem with the choice of the second candidate in that election. The section says the second candidate shall be the person with the majority of votes in the highest number of states in the federation. The first question, there are many other problems, but the first question is, who is the person that has majority of votes in the highest number of states in the federation?
Why is that a problem? Is it not easy to determine?
Oh, very difficult.
How so?
I can give you an example. There's candidate G.
Yeah.
Let's say he gets 20 million votes, and again he scored the highest, he scored majority of the votes in, let's say, 15 states. Then there's candidate F, who scores a total of, let's say, 25 million votes, and he has majority of votes in the first one. Did I say 20 states? 15 states. Okay, this one now, he has 25 million votes total and has majority of votes in 13 states. Who is the candidate with the majority of votes in the highest number of states? It's difficult.
But that makes them the candidate. That makes them immediately the candidates to do a runoff.
No, the first one is there. The first one is a person that got the majority of lawful votes. That is the majority of the votes cast in the election. So the problem is the choice of the second candidate. And from the example I gave, it is the man with less votes, less overall votes, who had 20 million votes, but with majority of votes in 15 states. That's will be the second candidate.
But some people will say that maybe the problems should present themselves first. I'm interested in a reading of 2 subsection B.
There's still another part of it, which I will
paragraph
continue.
B, yes, which says after talking about how he must have the highest number of votes, I don't know why the Electoral Act,
the Constitution,
always uses, I beg your pardon, the Constitution always uses he has the highest, maybe they already know that they're going to be men. He says he has the highest number of votes.
When they say he, it means both.
Both, okay. Fair enough. Yes. He has the highest number of votes cast at the election, and he has not less than 1/4 of the votes cast at the election each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. I find it interesting that you're reading the Federal Capital Territory as a separate requirement, as per having, you must have 25% in the Federal Capital Territory. You're not reading it as a part of the state, as a part of the general 2/3, because some people would have said, if the Constitution was going to include the Federal Capital Territory as one of the states, in what other language would it have done it than this?
The Constitution, I think it is in section 3 or one of the sections, those early sections, has specified the states in the Federation. They are expressly mentioned, and FCT is not mentioned as one of the states. And the expression used in this provision is states. Since FCT is not a state, FCT cannot be considered when computing 2/3 of the states of the Federation. So to be declared a winner of the election, the candidate must secure 1/4 of the votes in the FCT to win.
That's what I'm saying. So in 2/3 of the states,
yes,
perhaps including the Federal Capital Territory.
Separate. Federal Capital Territory for reasons of this provision.
Yeah, assuming this and the were changed to including the Federal Capital Territory, would it change how this is being read? I'm just wondering.
Maybe that's if it's amended, but for now we are dealing with the provision as it is.
And this has got to do with election that is, it says here, for 2 or more candidates. Now, it turns out, so if this presents itself, you're suggesting we will have a challenge on our hands.
In fact, I will explain a little bit further, but I have very serious fears that should that situation arise, and by any misfortune, INEC wrongly interprets the provisions of the Constitution and allows a candidate who ought not to participate in the second election to contest that election. The problems we may have on our hands are better imagined. Imagine a situation we have about 3 or 4 main presidential candidates, and for the first time, I think, in this present political dispensation, it's not too clear whether any of the candidates will meet the constitutional requirements in the first election. It's not too clear. So it looms large that there could be second and possibly third election. Are we prepared for it? And I must say that INEC, unfortunately, has already misinterpreted these provisions. This provision? Already.
This particular one or all of them?
This particular provision.
How so?
Relating to second election in paragraph 64 of the guidelines. In paragraph 64 of the INEC guidelines, it has stated that in a presidential election where 2 or more candidates have the highest number of votes, it can be read. INEC, the Electoral Commissioner, the Federal Electoral Commissioner shall not declare any of the candidates as the winner, but instead will conduct a rerun election, which it calls a rerun election, at a time to be specified by INEC. That is contrary to the provisions of the Constitution, 134, particularly 3 and 4, because those provisions have specified when the second and third elections can be conducted. And the situation envisaged by INEC in paragraph 64 of its guidelines is not
but
one of
INEC
them.
will still decide the date. I mean, INEC will still, it will follow the...
Not just the dates, the circumstances.
There should be a time frame, but the particular date, it is INEC that will select it, isn't that correct?
Yes, there's a time frame and INEC will select it. But it's not just about the time frame. The circumstances under...
surrounding that.
Yes, under which a second election can be conducted. And indeed, I would call for an urgent amendment of the provisions of this section, section 134 of the Constitution.
So
time
there you go.
is short, but they need to deal with it, because the problems that could arise from it, I better imagine, they could be very serious.
All right, we do thank you very much indeed.
Keg of gunpowder.
Mr. Kemasode Nwogu is a senior advocate of Nigeria, former Attorney General and Commissioner for Justice for Bayelsa State. Thank you for your time here today.